What are the disadvantages of filing for divorce first in New York? Filing first in a divorce case can feel like taking control, but in New York it sets off a chain of legal and personal obligations. The spouse who petitions becomes the plaintiff and chooses the initial county, yet that choice can be challenged later and the timing comes with rules. Courts require that either spouse live in the state for at least 2 years, or for 1 year if the marriage or grounds for divorce are connected to New York. Once the complaint is filed, the court issues automatic orders that immediately restrict both parties from transferring property, changing beneficiaries or incurring unreasonable debt. Assets are divided through equitable distribution, fair rather than equal, and filing first does not guarantee an advantage. Initiating the case may also create the perception that the petitioner is acting aggressively, complicating settlement talks. Taking the lead means paying the costs to start the lawsuit. The filing fee alone is at least $335, and additional charges are incurred for serving papers and hiring an attorney to prepare documents. Because the plaintiff sets the process in motion, they may need to retain a lawyer sooner and shoulder legal fees before the other spouse must respond. Courts often issue temporary orders for spousal support or child support early in the case, and those payments can be substantial if the petitioner earns more. Overpayments can occur when courts base temporary awards on incomplete financial information. The emotional impact of filing first is another critical consideration. Initiating the divorce can heighten feelings of guilt, anxiety, and uncertainty. The petitioner must gather documents, meet deadlines, and broach sensitive topics such as custody and property division. Serving papers without discussion may catch the other spouse off guard, leading to resentment and escalating conflict. The decision can strain relationships with children, relatives, and friends. A caring attorney can provide counsel, but the petitioner still bears much of this emotional burden. Filing first can affect child custody and parenting time. Family courts in New York focus on the best interests of the child and encourage both parents to remain involved. When one spouse petitions, the court may view that person as more assertive or controlling. Joint custody is typically favored unless a parent is unfit, so the respondent may use the time after being served to prepare for shared or primary custody. If the petition seeks sole custody or limits the other parent's visitation, the court may see the plaintiff as less willing to co-parent. Petitioners must show that temporary custody is in the child's best interests. Initiating a divorce also influences negotiation. Serving papers can trigger a defensive response that prolongs disputes over property, support, and custody. The respondent can tailor their counterclaims to the petitioner's initial filings, shifting the narrative and eroding the plaintiff's perceived advantage. Judges do not give preferential treatment to the filing spouse. Decisions are based on financial fairness and the child's best interests. Contested cases can drag on for months or years, generating substantial legal fees and emotional stress. Filing first reveals your goals, giving the other side time to prepare. An initial request that is too high may be hard to retract, while a low demand could leave the petitioner with less than they deserve. A skilled divorce lawyer can craft initial papers that preserve leverage, prepare accurate financial disclosures, and manage temporary orders. Careful planning can keep negotiations focused on settlement. Before choosing to file first, it is wise to consult a divorce attorney. The law office of Richard Roman Shum, Esq., has Manhattan divorce lawyers who offer pragmatic guidance to clients facing these decisions. Whether you plan to initiate a divorce or respond to a petition, this law firm can help you understand the financial, emotional, and legal implications and develop a strategy tailored to your circumstances. For personalized assistance, contact the law firm at 20 Clinton Street, FRNT 5D, New York, New York, 10002, or call 646-259-3416.